Unit 4, the Judicial Branch. Chapter 11, the Federal Court System. Look at Section 1, Powers of the Federal Court. Okay, our learning objectives. By the end of this lesson, you will be able to explain what jurisdiction is and which courts have which type of jurisdiction. Jurisdiction of the courts. The U.S. has a dual court system of state and federal courts. State courts have jurisdiction over cases involving involving state laws, and federal courts have jurisdiction over cases involving U.S. laws, foreign treaties, and the interpretation of the Constitution. In some cases, federal and state courts have concurrent jurisdiction, meaning that they have overlapping jurisdiction, or they both have jurisdiction in those cases. In the federal court system, trial courts are district courts that have original jurisdiction, which means that they're the first to hear the case. Federal courts of appeals have only appellate jurisdiction, or the ability to hear cases that have been appealed from district courts. Developing Supreme Court power. The Supreme Court has become the most powerful court in the world. It has gained power through custom, usage, and history. No federal court, including the Supreme Court, may initiate action. Now, what that means is that cases are brought to the court. The court doesn't go out and it can't start the process. For example, a court can't deal with an issue. It has to have a case connected to it. So if somebody feels that there's a new law that's unconstitutional, well, the Supreme Court can't issue a ruling on the law without a case to challenge that law. Also, they can't start criminal proceedings against somebody. The court can't go out and initiate criminal proceedings. But if somebody is arrested and charged with a crime, then the court may hear the case. Federal courts only determine cases. They never simply answer a legal question. Now, oftentimes, they may answer a legal question embedded in the case, but it starts with a case. That's the first step. They have to have a case initially. Chief Justice Marshall's decision in Marbury v. Madison established judicial review, or the ability of the court to rule on the constitutionality of an act of Congress, something that we now look for the court to do. Due process and regulatory power. The Supreme Court's rulings on the Reconstruction Amendments eventually applied these amendments to economic policy. In Plessy v. Ferguson, 1896, the court established the separate but equal precedent, which this became the basis of justifying the legalized segregation in the South. So this ultimately upheld it and said that you could legally separate the races as long as you were providing equal public facilities. And that would stand for 58 years until the court would reverse themselves in the Brown versus the Board of Education of Topeka, Kansas case, which we'll talk about later. In the Granger cases in the 1870s, the court held that a state had the power to regulate railroads and other private property. After Franklin D. Roosevelt's court-packing scheme of 1937 failed, the justices began to uphold laws regulating businesses. Under Chief Justice Earl Warren, the court emerged as a major force in protecting civil rights, beginning with the Brown versus the Board of Education of Topeka, 1954. This was the case that overturned the Plessy versus Ferguson separate but equal doctrine. because in the Brown decision, they said that separate was inherently unequal and therefore unconstitutional. Section 2, the lower federal courts. So what type of jurisdiction allows courts to hear appeals from lower courts? That would be appellate jurisdiction. Okay, our learning objectives is to explain how a grand jury differs from a petite jury. So looking at constitutional courts, the federal district courts were created by Congress as trial courts for both civil and criminal cases. In criminal cases, there are two types of juries. A grand jury, which hears charges against a person accused of a crime, and a petite jury, or trial jury, which weighs evidence presented at a trial. Now, to explain more clearly what that means, the grand jury ultimately determines if there's enough evidence for a person to really face charges. They don't actually hear the charges. They just hear evidence and determine if there's enough of it to justify the trial going forward. The petite jury or trial jury is where the person is actually going to either be found guilty or not guilty. In the vast majority of cases, district courts render the final decision. Many appointed officials provide services for district courts. The 13 courts of appeals ease the appellate workload of the Supreme Court. The courts of appeals may decide to uphold the original decision. They may reverse the decision, or they may send the case back to the original court to be tried again. The Court of International Trade hears cases dealing with tariffs. The legislative courts. Congress has created a series of legislative courts to help Congress exercise its powers. The legislative courts established by Congress include the U.S. Court of Federal Claims, the U.S. Tax Court, the U.S. Courts of Appeals for the Armed Forces, territorial courts, courts of the District of Columbia, the Court of Veterans' Appeals, and the Foreign Intelligence Surveillance Court. Selection of federal judges. According to the Constitution, the President has the power to appoint all federal judges with the approval of the Senate. Presidents often appoint judges from their own political party and judges who share a similar view on key issues. In selecting judges for trial courts, presidents follow the practice of senatorial courtesy, which basically means that they pretty much are going to approve whoever the president has picked. Almost all federal judges have had legal training. Many have served as state court judges. Women and minorities have been appointed as judges in federal courts in increasing numbers since the mid-1970s. Section 3, the Supreme Court. Our learning objectives for this section are to describe the jurisdiction of the Supreme Court and to explain how justices are appointed. The Supreme Court has both appellate and original jurisdiction. The court has original jurisdiction over two types of cases, those involving representatives of foreign governments and those in which a state is a party. Congress sets the number of Supreme Court justices. It has been 9 since 1869. The court consists of 8 associate justices and 1 chief justice. Congress sets the salary of the justices and may not reduce it. So in other words, this is set there. They don't want Congress to be able to punish the judges by lowering their pay, but in effect, they can withhold raises. Congress may remove a justice by impeachment for treason, bribery, or other high crimes and misdemeanors. The justices' duties are not defined in the Constitution, but have evolved from laws and through tradition, according to the needs of the nation. The justice's main duty is to hear and rule on cases. The Chief Justice also provides leadership for the court, presiding over sessions and conferences at which cases are discussed among the justices. The justices also have limited duties related to the 12 federal judicial courts, and on occasion they may serve on high-level commissions. Law clerks chosen by the justices help them research cases, summarize key issues in cases, and assist in writing drafts of the justices' opinions. Justices are appointed by the President and must be approved by the Senate. In the 20th century, most nominees were confirmed. Political considerations often play a major part in presidential appointments to the court. Members of the President's own party usually are named if the prospects of winning Senate approval are good. Now, of course, that also depends upon the makeup of the Senate. If the Senate is currently controlled by the same party as the President, then the President has greater latitude to get justices that they would like to see approved. But if the opposing party controls the Senate, they're probably going to have to find a justice that's a bit more moderate in their views. The American Bar Association, a national organization in the legal profession, has played an important role in the selection of justices by rating nominees' qualifications. Interest groups such as organized labor, civil rights groups, and the National Organization for Women attempt to influence senators voting on nominees. Sitting Supreme Court justices may have considerable influence in the selection of new justices. Now looking at Supreme Court decision-making. Chapter 12. Section 1, the Supreme Court at work. Our learning objective for this section is to explain how the Supreme Court selects, hears, and decides cases. Looking at the court's procedures. During 2-week sessions, justices hear oral arguments on cases and then meet in secret to make decisions. The justices consider arguments in cases they have heard and petitions from plaintiffs, and then write opinions for the cases that they have decided. Now, the plaintiffs are the people, of course, that are bringing a suit. Justices' written opinions interpret the law and help to shape public policy. The majority of referred court cases concerns appeals from lower courts. Most appeals concern cases in which a lower state or federal court has ruled laws unconstitutional. Cases the court chooses not to hear are dismissed, and the ruling of the lower court becomes final. Most cases reach the court by writ of certiorari, in which either side petitions that a lower court's decision involved an error, raising a serious constitutional issue. The Solicitor General is appointed by the President and represents the federal government before the Supreme Court. The Chief Justice puts worthy certiorari cases on a list for discussion. 2/3 of all certiorari cases never make the list. If 4 of 9 justices agree, the case is accepted. Some cases are decided by a brief, unsigned per curiam opinion. The rest are given the court's full consideration. Each side submits a brief detailing legal arguments, facts, and precedents. So in other words, attorneys do a lot of research, and they find other court cases that help to establish precedents. They spend a lot of time in legal libraries searching through previous court cases that they can find to make an argument that's going to support them, in addition to including the facts of the case and any other legal arguments they make. They want to back those with other decisions. Parties not directly involved with, but have an interest in the case, may submit amicus curiae briefs. Lawyers for each side make oral arguments during which justices may ask questions. On Wednesdays and Fridays, the Chief Justice presides over a secret conference in which each single case is summarized and recommendations for handling it are made. The justices spend about 30 minutes debating each case. Each justice has one vote, and a majority vote is needed to decide a case. The justices may issue four kinds of opinions: a unanimous opinion, which means everybody voted the same way; a majority opinion, which means a majority voted in one way or the other; a concurring opinion; or a dissenting opinion. If the Chief Justice votes with the majority, he or she assigns a justice in the majority to write the court's opinion. If not, the most senior justice with the majority assigns the justice to write the opinion. Section 2, Shaping Public Policy. Looking at our learning objectives for this section. Our learning objective is to identify ways the Supreme Court shapes public policy and to explain the limits on the court's power. Now looking at the tools for shaping public policy. The court determines policy in three ways. One, using judicial review, which once again we've already established that's the way in which a court determines the constitutionality of laws. Interpreting laws. So, in other words, they're in effect determining policy by their interpretation of a law. They can also overrule or reverse its previous decisions. Using judicial review, the court may examine laws and actions at all levels of government and cancel them if they violate the Constitution. The court uses judicial review most often to review state and local cases, but sometimes its review of federal cases can have tremendous impact on the nation, as in the Brown case from 1954 and the Miranda case of 1966. The Brown case is, of course, that's the case that overturned the separate but equal doctrine, and then the Miranda case is the case which has established the Miranda Rights that police read to people when they're arrested. The court's interpretation of the very general language of laws allows it to decide how the laws apply to specific situations. The court's rulings become precedents on which to base other similar decisions. However, since times change, the court may overturn or reverse its earlier decisions, as they did in the Brown case when they overturned a previous doctrine of separate but equal. Some Supreme Court decisions have resulted in great social upheaval. Limits on the Supreme Court. Generally, the court's decisions have dealt largely with civil liberties, economic issues, federal laws and regulations, due process, and suits against government officials. The court plays only a minor role in the area of foreign policy. Civil liberties cases make up the largest number of court cases. Appeals from prisoners comprise about 1/4 of its cases. By its rules and customs, the court hears only cases where its decision will make a difference, not merely those which decide a point of law. Plaintiffs must have suffered real harm, or cases must involve a federal question. The court avoids political issues. Since the court can decide only those cases that come to it from elsewhere in the legal system, events beyond the court's control shape its agenda. The court may signal its interest in a subject by taking on a specific case. The court's power to shape public policy is also limited by its own limited ability to enforce its decisions. Non-compliance by other courts is also difficult to monitor. Now, one example of this having a problem enforcing a decision was the Cherokee Nation, back in the age of Andrew Jackson, contested the Indian Removal Act. And they took it all the way to the Supreme Court, and the Supreme Court found in the favor of the Cherokee Nation. But President Jackson stated, well, now they made their decision, let's see them enforce it. And he went ahead and carried out the Indian Removal Act, even though the Supreme Court had said it was unconstitutional. Section 3, Influencing Court Decisions. Why are Supreme Court decisions so important? our learning objectives for this section is to describe the forces that shape the Supreme Court's decisions. Basing decisions on the law. Justices must base their opinions on the law, not on personal opinions. The court must interpret laws and relate their interpretations to the Constitution itself, relevant statutes, and legal precedents. The views of the justices. Justices monitor important issues. Some become identified with them. As justices retire, the majority voting blocks on certain issues may change. In other words, generally speaking, the makeup of the court tends to be either conservative or liberal. Generally the justices are going to kind of fall into one of those basic two camps. And of course it may vary on certain issues. Some justices may be more conservative on some issues than on others. But if we talk about a voting block, there are certain types of issues that, depending upon the makeup of the court, how many conservatives versus how many liberals on a particular type of issue, that may change as different justices are appointed, and it may cause a change in the direction that the court tends to base their decisions. Now looking at relations among the justices. Modern justices meet for discussion, but they communicate mostly in writing. Personal relations among justices may influence the court's decisions. The Chief Justice's skillful leadership can help promote harmony. The court and society. Although insulated from public opinion and political pressures, the court needs public support. Its authority depends in part on public acceptance. Justices are influenced by the values and beliefs of society. Their decisions usually reflect important societal changes. So, in other words, as the overall opinion of the public changes on an issue, we can expect that the court's overall opinions will tend to reflect the general direction that society is moving towards. And of course, it's important to note that the judges themselves are a part of society, so they're influenced by these changes in society. Balancing the court's power. The power of presidents to fill vacancies in the court, as every full-term president but Carter has done, gives presidents influence over the court. As the head of the executive branch, the president is responsible for enforcing the court's decisions, but he or she may do so vigorously or with little enthusiasm. Congress has the power to limit the court's ability to hear certain cases. They may propose a constitutional amendment to overturn a decision. They may set, but not reduce, the justices' salaries, and it uses its confirmation power to shape the court's position on social issues. And now we're going to move into Chapter 15, looking at law in America, and we're going to skip ahead of skip Section 1 because we've already really covered the information in Section 1 in a previous unit. But we're going to move into Section 2, looking at civil law. Okay, and we'll start by looking at the different types of civil law. Civil law, which concerns disputes between two or more individuals or between individuals and government, makes up about 90% of the cases heard in state courts. 4 of the most important types of civil law deal with 1. Contracts, 2. Property, 3. Family relations, and 4. Civil wrongs causing physical injury or injury to property, which would be known as a tort. Contract law involves a contract or a set of enforceable voluntary promises. Property law deals with the use and ownership of property. Family law deals with relationships among family members, such as marriage, divorce, or child custody. Civil wrongs or torts deal with any wrongful act for which the injured party has the right to sue for damages in a civil court. Equity law settles disputes on the grounds of fairness. Now looking at steps in a civil case. In a civil case called a lawsuit, a plaintiff seeks damages, usually an award of money from the defendant. To begin, the plaintiff usually hires a lawyer, either on a contingency fee, which is usually about anywhere from 20 to 50% of the total award, or for an hourly fee. Now, of course, typically attorneys are very expensive when you're paying by the hour. So the contingency fee is kind of nice because you only pay if you win, but if you win, you'd be looking at ultimately losing anywhere from 20 to 50% of the total amount that you win in attorney fees. Most lawsuits go to state courts, and the plaintiff sets forth the charges against the defendant in a complaint. During discovery, each side prepares for the trial by checking facts and gathering evidence. About 90% of all civil lawsuits are settled before trial. If all else fails, the civil lawsuit goes to trial, in which procedures are similar to those in criminal trials. Civil lawsuits are either tried by a jury or by a judge who decides the verdict. When the plaintiff wins, the court awards damages. However, if the defendant refuses to pay, the plaintiff must get a court order to enforce payment. So sometimes it can be very difficult to actually get a payment, or to enforce payment, even though you've been awarded the damages. Small claims courts. Most states provide an alternative to lengthy civil trials by setting up small claims courts. Small claims courts hear civil cases dealing with collecting small debts, property damage, small business problems, and the like. Small claims court cases are usually heard by a judge and involve maximum claims of $1,000 to $5,000, depending on the state. The judge's decision is legally binding. Now we look at criminal law. The types of crime. Most crimes committed in the United States break state laws. Each state has its own penal code or written laws that spell out crimes and punishments. Crimes may be petty offenses, misdemeanors, or felonies. Petty offenses are minor, like illegal parking. Misdemeanors are more serious crimes like vandalism, and felonies are serious criminal acts like murder, robbery, or kidnapping. The prosecutor or government lawyer responsible for bringing a criminal charge must prove beyond a reasonable doubt to a judge or a jury that the defendant violated the law. Criminal cases begin when the police gather enough evidence to convince a judge to issue an arrest warrant. The arrested person is taken to a police station, the charges are recorded, and the suspect may be fingerprinted and photographed. The arrested person is brought before a judge as quickly as possible to be formally charged with a crime. If the case is a misdemeanor, the person may plead guilty or not guilty. Cases may then go to a grand jury, which determines whether there's enough evidence to put the accused person on trial, or to a preliminary hearing before a judge for the same purpose. Steps in criminal cases. At this point, about 90% of criminal cases end in a guilty plea in which the accused pleads guilty to a lesser crime in return for the government's not prosecuting the more serious original crime. And this process is known as plea bargaining. After a grand jury indictment or preliminary hearing, A judge reads the formal charge at an arraignment held in an open courtroom. The defendant may plead not guilty by reason of insanity, guilty, or no contest. In felony cases, the defendant may choose between a jury trial and a bench trial heard by a judge. Jurors listen as witnesses are called and the evidence is presented. In jury trials, the presiding judge instructs the jury on the proper legal procedures and explains the law. The jury does not go to a jury room to review the evidence and reach a decision. The jury goes to a jury room to review the evidence and reach a decision. To reach a guilty verdict, the jury must find the evidence convincing beyond a reasonable doubt. If the jury's verdict is not guilty, the defendant is released immediately. If the jury's verdict is guilty, the judge usually... Criminal cases, Government Unit 4A. Criminal cases. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This according to the Sixth Amendment of the Constitution. I'm going to clarify a little bit more what that means. When we see a right to a speedy and public trial, that doesn't necessarily mean that everything in the trial is going to be made available to the public, and that doesn't necessarily mean, speedy doesn't mean right away. Speedy could mean basically without unnecessary delay. Oftentimes there's a backlog in the court system, so things don't happen as fast as we might like. But it's the point of that is that they don't want people to be locked up while waiting for a trial that's delayed simply for the basis of keeping them locked up. And once again, the idea of an impartial jury is that the jury should be unbiased, and it should be a jury that is composed of people where the crime took place. Now, there are some exceptions where a trial can be moved, and we'll talk about that a little bit later, why there might be a change of venue. But generally speaking, it should generally be where it took place. For example, usually in the same county. And once again, they should be informed of the nature and the cause of the accusation. Whatever they're charged with has to be presented to them. They have to be confronted with the witnesses against them. In other words, they have the opportunity to see who is making these accusations against them as this goes through a court of law. And this idea of having a compulsory process, what that means basically is that there is a way that they can force people to testify. And that's really through the process of subpoenaing witnesses. Subpoena is basically a legal order to appear, and they can use that frequently times. So, that's what compulsory means, is basically mandatory. They can force people to testify. So, if I know somebody is a potential witness for me and I'm accused of a crime, I could force them. I could have them subpoenaed so that they're forced to testify, even if they don't feel like testifying. And then, once again, to have assistance of counsel, what that means is basically they have the right to an attorney. And we now know that not only do they have the right to an attorney, but if they can't afford one will be appointed for them. That's called a public defender. A primary function of the criminal justice system is to punish people who have committed crimes. The process established by our government involves numerous steps that often lead to backlogs and delays. However, these are a necessary evil because through the U.S. Constitution, all Americans, regardless of the crime that they're accused of committing, are guaranteed basic fundamental rights. Balancing the rights of the accused with the responsibility of protecting society is a daunting task for those who work in the justice system. In a criminal case, the accused is charged with committing an offense against the public in general, although an individual may have been wronged, and in such cases, these individuals are free to file a civil suit against the defendant. Now, it's important to note here what we're talking about when we say a criminal trial. Crimes aren't committed against individuals per se. The crime is against society. And that doesn't mean there can't be a victim of that crime, but it's a crime against society. In other words, they broke the law by doing something that is criminal. Now, victims who are damaged by that criminal act can file suit for those damages. So let's take the case of a murder. If somebody has murdered somebody, yes, there is a victim. The individual that was murdered is a victim, but it's still considered to be a crime against society. And so they're charged with committing murder. That's the criminal trial, and that is, once again, a crime against society. Now, the victim's family could then file a wrongful death lawsuit against the accused. And important point here is that in a wrongful death lawsuit like that, which is a civil suit, it is not necessary that they get a conviction in the criminal case. One example of this was the O.J. Simpson trial, where O.J. Simpson was accused of murdering his ex-wife, Nicole Brown Simpson, and another man named Ron Goldman, who had the misfortune of being basically in the wrong place at the wrong time. In the criminal trial, O.J. Simpson was acquitted. He was found not guilty. Now, it's important also, an important distinction to note that a not guilty verdict doesn't mean that the person is innocent. Our courts do not find people innocent, and that's because there's no burden to prove you're innocent. The burden falls on the state or who's bringing the charges. They have to be proven to be guilty. There is a presumption of innocence, and a not guilty verdict simply means that the burden of proof was not established. They didn't prove beyond a reasonable doubt that the person was guilty. Not meaning, of course, that they're innocent. Most people believe that O.J. Simpson was guilty, and the general public, that's kind of seems like it's been a consensus opinion ever since the trial. But the criminal case found him not guilty. And once again, when you're found not guilty, you cannot be tried for the same crime twice. So he was acquitted. That's all that could be done. So the families turned around, and then they filed a civil lawsuit for wrongful death. Now, there's a different standard of proof in a civil case. They just have to prove a preponderance of evidence, which basically means they have to prove that there's more evidence the person is responsible than they're not responsible. So it's a lower burden of proof to hit than to prove somebody guilty beyond a reasonable doubt. So in that case, O.J. Simpson was found to be responsible for their deaths, and even though he was acquitted of the murders. However, in most civil cases, the punishment is financial. And O.J. Simpson did a good job of hiding his assets so that he didn't have to surrender a lot of things. Now, kind of an ironic twist, many years later, O.J. Simpson, having given away a bunch of his possessions to get them out of his name, lost control of some of his sports memorabilia and decided he was going to steal it back at gunpoint. And for that, he ended up being charged with armed robbery and was convicted. And so then he later went to prison for armed robbery. Now, the process. After an investigation, the government, working on behalf of the people in a state or the people of the United States, arrest a suspect, in this case for kidnapping, we'll call him Larry, and they charge him with a crime. Police can't use this power indiscriminately since they must have probable cause, which is a good reason to believe that Larry has been involved in a crime. According to law, when a person is arrested, the police must read him his Miranda rights. These rights came out of a Supreme Court case, Miranda versus Arizona, in 1966, where the court found that it is the duty of arresting officers to inform someone of their rights. So ever since then, we've had the Miranda rights, and people have become very used to them. Most people kind of know them, which is, of course, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be appointed to you, etc., etc., etc. So they have to read them the rights, and then, here you can see, actually right in the text, Larry would be told, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney present with you during questioning. If you cannot afford one, one will be appointed to you by the court. Do you understand? After the arrest, Larry is booked, fingerprinted, photographed, arrest records are filed, and his personal information is entered into a database for future reference. But before he's locked in a cell, he has the right to make one phone call. And he will probably call a lawyer or someone who can find a lawyer for him. Larry's case is then handed over to a prosecuting attorney who represents the government. If the prosecuting attorney believes the case against Larry is weak, he may drop the charges and Larry will be released. However, if the prosecuting attorney thinks that there is enough evidence to put Larry on trial, a preliminary hearing is held. And so I said, this is one of those situations where usually it's the district attorney, in most cases, they're going to make that decision, that determination. And so if a preliminary hearing is held, Larry has the right, as do all persons accused, because of a writ of habeas corpus, which is a court order that guarantees him a right to appear before a judge in a court of law. And so at this point, the preliminary hearing is held. He appears before the judge. At the preliminary hearing, which must occur soon after Larry's arrest, the prosecuting attorney must show the court that a crime has been committed and that there's enough evidence against Larry to charge him with the crime. If the judge agrees, he may set bail or he may release Larry on his own recognizance. In this case, if the judge feels that he's a flight risk, he may completely deny bail. And a flight risk is somebody who they think is likely to flee. In most severe cases, bail may be set very, very high. For more minor cases, bail is usually a much lower amount. And then, like I said, in some cases, especially if the crime isn't that severe and they don't think Larry's much of a flight risk, releasing him on his own recognizance simply means that he's allowed to basically go free until the trial. And if the judge disagrees, he'll dismiss the case and Larry will be released. So it's really up to the judge's discretion whether he thinks there's enough evidence. Assuming that the judge rules in the prosecution's favor, according to law, Larry must be given the opportunity to have a lawyer, even if he can't afford one. Public defenders are lawyers who work for the government and who represent defendants who can't afford legal counsel. Now, there's definitely an argument that says that you kind of get what you pay for. I mean, if you have the money to hire the best attorneys that money can buy, you are less likely to be convicted. If you're stuck with a public defender, that doesn't necessarily mean that the public defender isn't a good attorney. But then again, the public defender doesn't have all the resources and may not be as good as somebody in private practice. But once again, even if you go for somebody in private practice, the more you can afford to spend generally, you can get a better attorney. Now, of course, that doesn't mean that just because an attorney is expensive that they're good either. But certainly, better attorneys can usually charge a lot more. So we like to think that our court system is fair and equal, but in that sense, it isn't very equitable because, yeah, if you can afford the best attorneys, you do have an advantage. The grand jury. Larry's case is then turned over to a grand jury. The grand jury is composed of 16 to 23 citizens who review cases and decide whether or not there's enough evidence to formally charge Larry with a crime. The grand jury does not decide guilt or innocence. Rather, its job is to determine whether or not there is probable cause that Larry committed a crime. If it doesn't find probable cause, the case is dismissed. If the evidence does indicate probable cause on Larry's part, the grand jury will return an indictment, which is a formal charge against the accused. So you can see this is kind of a multi-step process. The judge at the preliminary hearing could have ruled that there wasn't enough evidence and Larry could have been released. Or things could move to the grand jury, but the grand jury may fail to indict, at which point Larry could be released. But if the grand jury does find that there's enough evidence and they issue that indictment, then they basically made a formal charge and it moves forward to the next step, which is arraignment. After the indictment, Larry will consult with his lawyer before appearing in court again for his arraignment. At this court hearing, Larry enters a plea of guilty, not guilty, or no contest. The defendant, under no contest, the defendant doesn't admit guilt, but acknowledges that a jury would probably convict him based on the evidence. So it's not quite the same thing as a guilty plea. A guilty plea, you're basically saying, yeah, I'm guilty, I did it. Not guilty, you're going to fight it. No contest, you're not admitting guilt, but you're not going to fight it because it probably wouldn't be successful. If Larry enters a plea of no contest or guilty, the judge will sentence him and the case is over. Larry may decide to plead no contest or guilty if the evidence against him is strong, because through a plea bargain, he will receive a lighter sentence. Most cases are settled in this way. If Larry enters a plea of not guilty, then the judge will set a trial date. Pre-trial motions. Before the trial begins, the lawyers for both the prosecution and the defense may file motions to suppress certain evidence or statements, or perhaps to ask the judge for a change of venue, which means moving the trial to a different location, usually because of extensive pre-trial publicity. One case where this happened, that was a local case, was the Scott Peterson murder trial. Scott Peterson was charged with murdering his pregnant wife, Lacey, and their unborn child. And, leading up to that case, there had been a great deal of media attention nationwide. Lacey Peterson went missing on Christmas Eve. And back in, I think it was 2002, I believe. And so, it's now been several years, but she went missing, and for really probably, at least a couple of months, 2 or 3 months, they were searching for her, searching for answers, trying to figure out what happened to her, and no one knew whether she was alive or whether she was dead. Eventually, her remains, along with the remains of their unborn child, Connor, washed ashore, and shortly after that, Scott Peterson was arrested and charged with the murder. And the case, like I said, was attracted so much public attention. I mean, within a few days after her disappearance, it was all over the national news media. And so there had been so much media attention, it was hard to find people that hadn't followed the case and had an opinion about it, even on a national basis, but especially here in the local area. And so there was a change of venue. I can't remember exactly what county they moved it to. It was somewhere kind of more towards the Bay Area, but they did get it out of Stanislaus County because of the intense media coverage that had existed. In a situation like that, where a case has been so high profile, it is hard to find a jury that hasn't been tainted, or a jury pool, I should say, that hasn't been tainted at all. But it is what it is, and so that's why typically you have a change of venue. Also, as a part of the pre-trial motions, they will issue subpoenas or court orders requiring a person to appear in court that are sent to witnesses. And once again, I mentioned that compulsory process. The defendant can compel people to testify, but the prosecution also can subpoena witnesses as well at this point in time. Then we move forward to the main trial, which is known as the petite jury. Before the trial begins, Larry will be asked if he wants a bench trial. Approximately 10% of all criminal cases are bench trials, which is simply a trial by a judge who decides the verdict. However, Larry will probably opt for a trial by a jury of his peers, formally called a petite jury. Once the trial begins, Larry's fate will lie with this group of men and women who hear the evidence and decide whether or not Larry is guilty or not guilty. Jurors are selected after extensive questioning by the judge and the lawyers. So, the selecting the jury, known as the voir dire, and I probably butchered the pronunciation of that. It's Latin. The first step in a criminal case is the selection of an impartial jury. Serving on a jury is both a privilege and an obligation. Most people truly don't want to get jury duty, but from a standpoint of making our system work, it is important that we can compel people to serve on juries. Our system would not work if we didn't have jurors. In a democracy, it is essential for the citizens to participate in the criminal justice system if the government of the people is to survive. So, while I never like getting a jury summons and always hope that I end up not on the jury, at the end of the day, it's important that we participate. Not all citizens are eligible for jury duty. Therefore, being selected to decide the fate of a peer is a privilege that is not granted to all. Although each state establishes its own guidelines regarding jurors, in most states, potential jurors must be between the ages of 21 and 70. And they must be literate, meaning they can read. And they can't have a felony conviction. All jurors must be U.S. citizens either by birth or through naturalization. States derive their juror list in multiple ways, but most states use tax lists, the list of registered voters, or the list from the Department of Motor Vehicles. Drawn randomly from these lists, citizens are notified to come to court for jury duty. Collectively, they are called the jury panel. On the day of a trial, there may be as many as 150 jurors. Of this number, generally 12 will be selected as jurors along with 2 alternates. There may be as few as 6 jurors on a case, and this really varies a little bit depending upon the particular laws of the state. But generally it's going to be about 12 with 2 alternates. The alternates don't participate in deliberations, but they sit through all the testimony in the trial. The whole purpose of being an alternate is that should, for some reason, one of the jurors who's actually, one of the main 12 jurors not able to fulfill their duty, then they would be replaced by the alternate. Jurors from the panel are selected randomly, usually by lot, until the jury box is filled. At the opening of court, the judge calls for excuses, and the jurors who believe that they should be excused are asked to give their reasons. The judge listens to each excuse and rules on each case immediately. Excuses such as having to care for a seriously ill family member will usually lead to dismissal. Excuses such as previous engagement, such as tickets to a sporting event, for example, will not be valid. The judge looks at the circumstances of each individual juror before making a final decision. And sometimes a juror may decide to leave or the judge may decide to leave a potential juror on temporarily and kind of see what develops. But as they do this and they make, potentially excuse some jurors, how strict the judge will be depends on a wide variety of factors. Partially depends on the judge. Some judges are probably just more lenient than others, and also it probably depends on how close they are to filling the jury. If the judge is very confident that he's got a good selection of potential jurors and he's not going to have a problem filling any remaining spots, he might be more willing to accept an excuse that he otherwise normally wouldn't accept. So there isn't a precise line where we can say, well, this excuse is absolutely going to be, we get a juror excused, and this absolutely wouldn't. It's a little hit and miss. After the excuses have been heard and the jurors dismissed, if necessary, additional jurors are called so that the number of jurors in the jury box remains consistent. The jurors are then questioned by the judge and then by the lawyers. In a criminal case, the defense questions the jurors first and is followed by the prosecution. This preliminary examination is called the voir dire, and its purpose is to obtain a fair and impartial jury. Jurors may be asked about their personal lives, about their relationship to any of the parties involved in the case, about any aversion to the type of case being tried. For example, if let's say somebody has an objection, a moral objection to the death penalty, and it's a murder case where the death penalty is a possible verdict. That person might be excluded for the simple reason that morally they might have a hard time convicting. So they'll look at things like that. They'll look at the previous knowledge of the case that they might have, and once again, that could tie into how closely they followed the case in the media. Regardless of the type of question asked, all jurors must respond truthfully. The lawyer's questions are not intended to offend jurors, although sometimes they do. And since they don't want to alienate a juror who will be deciding the outcome of the case. In other words, if you're an attorney and you're asking a question of a potential juror, you do want to be able to excuse a potential juror that you think may be bad for your side. But in doing so, you don't want to alienate them in case they do end up on the jury, because then you may have already turned them against your side in the case. After questioning, jurors may be excused in one of two ways: a challenge for cause or a peremptory challenge. A lawyer may ask for a challenge for cause, which is a request to the judge that a juror be removed for a specific reason. The reason stated must show that the juror can't be impartial in the case. Some examples are a prior relationship between the juror and one of the parties in the case, prior knowledge of the case in which the juror has already formed a concrete opinion, or a prejudice on the part of the juror. So this is something that, like I said, the attorneys are trying to determine. They're going to ask questions, and they're looking to see, one, if they do have a clear cause where they can, make a challenge for cause. But if they're making a challenge for cause, they have to state why. And they have to convince the judge that this person is not an impartial, or would not make an impartial juror. So keep in mind that all people have prejudices because of our backgrounds, lifestyles, experiences, etc. Therefore, a lawyer must prove the juror's prejudices will inhibit the juror from being impartial in the case before him. After the lawyer makes his argument, the judge must decide whether or not he agrees. If he agrees, the juror is excused. If he disagrees, the juror remains unless the lawyer chooses to use one of his peremptory challenges. And there is no limit on the number of challenges for cause that a lawyer may use. But keep in mind that every challenge for cause, the lawyer has to prove that that person, to the judge's satisfaction, that person would not be a good or an impartial juror. If a lawyer has a bad feeling about a juror, or he believes that the person is biased, maybe he just has a gut feeling about it, but he can't offer substantial proof for dismissal, the juror may be excused through the use of a peremptory challenge. According to state laws, each side is given a limited number of peremptory challenges, but they can be used at any time to excuse a juror without stating any cause whatsoever. Usually they're going to go through and question, and if they find a good case that they think they can really make a challenge for cause, they'll make a challenge for cause. If they're unable to do that, then they'll go to the peremptory challenge. We have definitely used peremptory challenge, or seen peremptory challenges used before. The last time I got called for jury duty, I actually was in one of the alternate chairs. And kind of the way that things would work is that they were at that point where, in the event that they'd gone through basically all the challenges for cause, so the jury was basically set except for peremptory challenges. So each side had peremptory challenges. And they went to the prosecution first, asked the prosecution if they wanted to use any of their peremptory challenges. The prosecution did not use any of their peremptory challenges. They had two. So then they went to the defense, and the defense chose to dismiss me and then chose the person sitting next to me as peremptory challenges. But we were basically at that point, based on where I was sitting, I would have been at least an alternate had I specifically not been excused. So that's how close it was. But ultimately, the defense didn't have a good feeling about me for whatever reason. But they didn't have to state it and make that case. They just, if they felt uncomfortable, and if for any reason any of the potential jurors have the least little bit of doubt in that juror, they might as well use their peremptory challenges because they want to get the most favorable jury they possibly can. The judge cannot overturn a peremptory challenge, nor can the opposing side object to it. When using a peremptory challenge, the lawyer simply states the prosecution exercises a peremptory challenge against Mr. Williams, and Mr. Williams must step down. As jurors are dismissed, new jurors are called to take their place. When the selection of the jury is completed, the judge orders the clerk to swear in the jury. And the oath states, "You and each of you do solemnly swear or affirm that you will, well and truly, try the issues joined in the cause now here pending, and unless discharged by the court, a true verdict render, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court, so help you God." After the jurors swear in the affirmative, the trial continues with the opening statements. After the jurors are selected, the trial begins with the lawyer's opening statements. The prosecution gives its statement first. The prosecuting attorney outlines the case and tells the jury about the evidence that he plans to present to prove his case. The defense lawyer may follow immediately and give his opening statement, or he may wait until the prosecution rests its case. Jurors must remember that these statements are not evidence. Their purpose is to give the framework, the points of conflict, and the issues of the case. Then we move on to testimony. The next phase of the trial takes place when witnesses are called and questioned by both sides. After both sides have rested their cases, each lawyer gives his summation or closing statement. In most states, the defense gives its statement first, and then the prosecution follows. This is the lawyer's last opportunity to address the jury, so they will reiterate the facts that support their sides in a final attempt to convince the jury that they are right. Then, after receiving instructions from the judge, the jury retires for deliberations. In some states, the jury not only determines guilt or innocence, but also decides the sentence. Verdict. A jury must decide unanimously if Larry is guilty beyond a reasonable doubt. If the jurors are not sure, they must find Larry not guilty. If the jury can't decide, it is called a hung jury and a mistrial is declared. However, jurors must make a concerted effort to reach a verdict, and often jurors are repeatedly told by the judge to go back into deliberation until a verdict is reached. The judge doesn't want to declare a mistrial. So if they're unable to reach a verdict, the judge is likely to send them back and continue to send them back until the judge is convinced that there is just no way that they're ever going to reach a verdict. But like I said, the tough thing is that they really need the jury to be unanimous. To get a guilty verdict, everybody has to vote guilty. If it's divided, if everybody says not guilty, it's not guilty. If everybody says guilty, it's guilty. But if it's divided, they have to keep trying until they either reach a verdict and the judge is satisfied, or finally the judge may declare a mistrial. So if it goes that far and it becomes a mistrial, the reason why the judge doesn't want to declare a mistrial, will send them back time and time again, is primarily because of the time and the money that has been spent on the trial. You have to remember, trials are extremely expensive for both the prosecution and defense. In the event of a mistrial, if it's declared, the prosecution has the option of trying the defendant again or dropping the charges. And such a retrial is not considered to be a violation of the constitutional protection against double jeopardy because a verdict hasn't been handed down. Once acquitted, in other words, once found not guilty, they cannot be charged again. However, if they don't determine a verdict, they haven't handed down a verdict, they simply declare a mistrial, the prosecution still has the ability to try that case. But in that situation, there is going to be a tremendous expense for the state to retry that case. And ultimately, they have to ask that question. Is it worth it? Would they have a good shot at getting a conviction in a retrial? And that's what they have to determine. If they don't think there's a good shot, a really good shot, at getting a different verdict the next time around, they think it's likely to end in a hung jury or an acquittal, they're not going to waste the money, they'll drop the charges. After the jury has reached a verdict, it returns to the courtroom and the judge asks if it has arrived at a verdict. And the foreman, speaking on behalf of the group, answers in the affirmative. If the defendant is found not guilty, he is acquitted. And if he's found guilty, he can appeal the decision. After the foreman reads the verdict, the clerk calls on each juror by name and asks them if they agree with the verdict. After the jury has been polled, the jury's function is complete. The lawyers may continue to make motions and the case may be appealed, but the judge will excuse the jurors. Now, like I said, in some cases, the jurors do have a say in sentencing, but not always. But when they've determined the guilt and the verdict is determined, like I said, in the case of an appeal, if it's a murder case, where there's the death penalty, there is indeed a mandatory appeal. It's automatic. Normally, to gain an appeal, they have to show that there has been something done that wasn't right. which usually isn't too hard. They find some mistake, or they claim the judge acted improperly, or that maybe they could claim the defense attorney was incompetent, or there's all kinds of different things that they could claim. But they just need just enough doubt to open the door for a possible appeals trial. Now, after all of that's done, they move to the sentencing phase. If Larry's found guilty, the final step in the court is the sentencing phase. Most states set a maximum and a minimum sentence for each crime, thus leaving room for the judge to decide the exact sentence. The judge will consider many factors when making his decision, such as the nature of the crime, Larry's previous criminal record, his age, and his attitude. If Larry receives his sentence, or after Larry receives his sentence, the trial is over.